Welcome and thank you for joining Seyfarth's webinar, Energy Law Updates, Legal Risk and Emerging Issues in Changing Industry, Part 2, Navigating DEI and Religious Discrimination in the Workplace. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right-hand side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for a CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees following the webinar. On the next slide, you will see the legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or legal opinion on any specific facts or circumstances. The content is intended for general information purposes only. You are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I'd like to turn it over to Annette Adalski. Annette, you may begin.
Thank you, Marianne. Welcome, everyone. Happy Tuesday. My name is Annette Adalski, and I'm one of the chairs of the Energy Practice Group at Seyfarth. It is my pleasure to introduce our panel of labor and employment experts. On our panel is Christy Kiley. She's a partner in the Labor and Employment Group in our DC office. She has over 20 years of experience focused on EEO, DEI, OFCCP, and pay equity. Christy helps employers manage their workforce efficiently and with minimal risk while honoring their core values. She helps employers navigate complex and shifting legal frameworks while considering the practical day-to-day realities of a business. A substantial part of Christy's practice is conducting DEI program reviews and risk assessment for clients. Also on our panel is Elizabeth Humphrey, who is a senior associate in the Houston office. She is a trusted legal advisor to employers on a wide range of employment matters, including the development and implementation of inclusion and belonging initiatives, infrastructure improvements to prevent future risk, workplace investigations, and post-investigation training. She also represents employers in single plaintiff and complex litigation involving federal and state anti-discrimination laws. And finally, our moderator today is Steve Chardonofsky. Steve is chair of the firm's Houston Labor and Employment Practice and is board certified in labor and employment law by the Texas Board of Legal Specialization. He is a trusted advisor and litigator and has successfully represented employers in federal and state courts in arbitration and before agencies such as the DOL, EEOC, and Texas Workforce Commission. We have an awesome panel today, and a lot of you are attending, a lot of our clients. We welcome you and appreciate your attending today. And with that, I'm going to turn it over to Steve.
Thank you so much, Annette. Welcome. We have a fantastic webinar planned for you today. As of last night, we had over 340 registrants. So I will be moderating our expert panel. Please do submit questions through the Q&A function. I promise to do my very best to incorporate your questions as we go through the presentation today. And at the end of the webinar, I will also provide the CLE code. This is the sort of the next installment in our energy law webinar series, focusing on the evolution of both DEI initiatives and religious accommodations, religious discrimination in the workplace. If you are not in the oil and gas industry, do not fret, right? The issues and the lessons that we'll cover today apply across the board. Before we get started, I've got some good news and maybe a little bit of bad news to share. My partner, John Phillips, who was supposed to present with us today, just got called away to handle an urgent client matter. We were planning to spend 15 or 20 minutes with John covering some novel religious accommodation issues. And everybody will get a copy of the presentation with his slides in case you want to refer to them, but we'll have to leave that part of the discussion for another installment of our energy law webinar series. The good news, though, is that we'll have that much more time to talk with Elizabeth and Christy about DEI initiatives and relative risks in the current legal landscape. So let's dive in. As most of you know, through various executive orders and other agency action, the Trump administration has been focusing on what they call illegal DEI. And in my own litigation practice, I've seen more and more of what we're calling reverse discrimination lawsuits that are based in part on the alleged illegal DEI, where the plaintiff uses the company's own DEI practices, statements about DEI or DEI goals against them in litigation. And I want to start off maybe with, I've got three initial questions, Elizabeth, for you and Christy. Christy, what is illegal DEI according to the government?
Well, that's the million-dollar question, right, Steve? That's what we're all spending, it seems like, all day, every day trying to figure out. If we go to the next slide, we can talk a little bit about where the focus on this term comes from, right? This concept of illegal DEI. So it goes back to a day 2 executive order that President Trump signed, Order 14173. They all have, it seems like, very long names, but the name of that order was Ending Illegal Discrimination and Restoring Merit-Based Opportunity. And what that order purported to do, or what it said it would do, is it was sort of aimed at rooting out unlawful DEI activity by employers in the United States. And I read that order multiple times when it first came out, and there's not a single place that talks about DEI without modifying it with that word unlawful or illegal. So the order was calling out illegal DEI practices. And on the one hand, you could say, well, if it was already illegal, it was already illegal, right? Why need an executive order for that? But the answer is because legality is somewhat in the eye of the beholder, or in this case, in the eye of executive leadership and the courts. And so there's a lot of gray area in DEI, especially with regard to the details of how a particular program might be implemented or what a particular employer chooses to focus on. And so what was considered lawful in 2024, we're finding may not necessarily still be lawful in 2025. And so even though the underlying laws like Title VII and other statutes have not changed at all, the way they are interpreted and viewed and applied to specific fact scenarios, that is changing. The good news is, as Elizabeth and I talked to you here today, we have gotten clarity on a few areas that certainly in the government's position do constitute illegal DEI, and we'll be giving you some specific examples of those. While there are other things we still feel very comfortable is lawful DEI. So there are a few sort of clear answers that are emerging over time, and then there's a whole lot in the middle that just still remains really unclear.
Just to sort of set the scope here, Elizabeth, does this, the focus here on illegal DEI, does this apply only to federal agencies or federal contractors, or does everybody need to be kind of looking at this carefully these days?
That's a great question, Steve. If we could go to the next slide, please. The next slide as well. As Christy mentioned, Section 3 of the executive order does impose certain requirements with respect to rooting out illegal DEI. Section 4 of the executive order explicitly directs the Attorney General and federal agencies to identify private companies and to take all appropriate action to eliminate illegal DEI discrimination with respect to those companies. And this enforcement directive does reach all private employers. The AG was also supposed to submit a strategic enforcement plan to identify the most egregious DEI practitioners in each sector. They were supposed to do that by May 21st, 2025. As of this morning, we still have not seen that plan. There are questions as to whether or not that report will actually be shared publicly, or if the administration will simply privately negotiate with investigation targets about their DEI programs. But some of the criteria for the investigation targets were publicly traded corporations, nonprofits with over $500 million in assets, and universities with $1 billion plus in endowments.
So, Christy, I wonder, is this current focus on unlawful DEI entirely new, or were there certain recruiting, compensation, other employment practices that were considered red flags or even possibly illegal before the Trump administration's current focus? And I'm sort of thinking about things like, I don't know, hiring or promotional quotas or performance reviews tied to DEI. I mean, were those things kind of risky even before the current focus?
The answer is absolutely yes, Steve. There certainly were things that were pushing the envelope, might be another way of saying it, under Title VII, even prior to the current administration. And President Trump in his first term was focused on DEI, right? This isn't an entirely new focus from him either. We're going to talk about DEI training in a little bit, and he issued an executive order dealing with DEI training in his first term. So it certainly has been a continued focus. But there absolutely have been practices that have been problematic, right, under Title VII that have been in place for some time. And actually, if we could go back one slide, Marianne, and look at this here, this is another one. What a lot of this comes from, by the way, I think the context is really helpful, is if we go back in time to 2020 for a moment, that was a really difficult time for employers in our country. That was when we had the death of George Floyd, we had Breonna Taylor, the rise of Black Lives Matter, and it was a very difficult time from a civil rights, race relations perspective in our country. And some employers felt really compelled to take action in response to what was going on in our society at that time. And I remember talking to some of my clients who wanted to do certain things like extend certain helpful or preferential considerations in a hiring practice, for instance. And I remember saying, I understand why you think you need to do this, but I'm telling you it violates Title VII. Right. And so a lot of what the current backlash from the administration on is it's on those efforts that did go a little bit too far under the law for really well-intended purposes. Right. So I think that's really important context to sort of know where some of this is coming from. But to your question of what was already problematic, so things that would inject any consideration of a diversity trait, whether it's gender, whether it's race, whether it's disability, anytime that's considered in the part of an employment decision process, that's a problem under the non-discrimination laws. Things like you mentioned quotas. Quotas have always been illegal, right? Quotas where you say, we're going to hire, 10% women for this job. That's never been lawful under any law, including federal contracting. What's less clear. Oh, sorry,
what if it's not a quota, but over the years, I think I've gotten questions from clients that they wanted to implement some sort of bonus for their recruiters to go out into the market and source candidates of a particular gender or race, and they get a bonus for doing that. In terms of the risk spectrum before the Trump administration, would that be pretty risky as well?
So the recruiting, I think, is a slightly different topic, which I know we're going to get to. I think what might be a good comparison point, though, is goals, like goals to increase diversity. That's something that was pretty common and different from a quota, right? A goal is where an employer might say, we aspire to have 20% minority leadership by 2030. That's a really common example of a goal. Or we want gender parity in our executive ranks by a certain time. That's an aspirational goal. It's not a quota, right? It's not saying go out there and hire someone. It's just saying we want to do better. We want to do better with diversity. There is nothing even today unlawful about having a desire to do better from a diversity perspective. But the problem was in application, especially when, as you said, Steve, you're tying it to compensation or bonuses or performance reviews. You are sort of implicitly or potentially motivating the decision maker to pick one person over another in order to make progress towards that goal and do better themselves financially. And so you have sort of this unintended consequence of motivating action based on traits like race or gender, which violates Title VII. So it's kind of a fine line between the goals and the quotas, but at the end of the day, there should be no consideration of race or gender in decision making, and that's always been the case.
So I think part of our goal today is to help employers, to help everybody on the call kind of decipher where that line is, and to give everybody an idea and some suggestions about, DEI initiatives, DEI practices that are nowadays risky, and those that are sort of, less risky or perhaps, lawful going forward in this climate. Elizabeth, sometimes when employees or managers hear the term DEI, they often default to thinking about race or gender, and as we move forward in the discussion today, and as you and Christy are helping our clients kind of revamp and rethink about their DEI programs, is that a fair way to look at it, or is there a broader way to think about and talk about DEI as we consider, the potential risks and solutions here?
Sure. So in my experience, people tend to focus on race and gender when they think about DEI, just because those are characteristics that we can easily see and assess, right? We're all humans and we use our eyes every day. That's our biggest sense. But employers should really be thinking about diversity of perspective overall, more comprehensively, and thinking about different backgrounds and experiences that can contribute to creating a variety of perspectives in the workplace. So this can include geography, undergraduate school size, growing up in an urban or a rural environment, participation in athletics. The list could really go on and on because we're so different in so many different ways. Another thing that I want to encourage employers to think about when they're rethinking their policies and initiatives is to really lean into the inclusion piece of the DEI. Policies that are grounded in principles of inclusion and belonging are much more difficult to challenge simply because they focus on creating an inclusive workspace where everyone can thrive and feel seen and appreciated for who they are, irrespective of their background. So in contrast, policies that are grounded in diversity and equity principles can become a little bit more myopic because they tend to lean towards being more outcome driven if we're not really careful about the implementation of those.
Thank you, Elizabeth. So part of the goal that Elizabeth and Christy and I had for this presentation is to, not spend a lot of time talking about esoteric legal issues, but to really focus on practical advice and talk about real world DEI initiatives. And that's what we're going to focus on for the rest of the presentation, in a number of sort of sections. And I want to start talking about, maybe chronologically, we can talk about recruiting and promotional practices, since that's, recruiting practices, that's sort of the first part of the employment relationship. Christy, can employers engage in efforts to achieve so-called workforce balancing? Maybe you can define what that is and tell us a little bit about what risks or potential liabilities there are in workforce balancing.
Absolutely. Yeah, workforce balancing kind of goes along with the concept of goals, right? Goals to do better with regard to diversity in an organization. Balancing is the concept that when you take into account people who are available to work for you as an employer, the folks out there in the job market who theoretically could be getting your opportunities, does your workforce match that? Do you have a balance between who you could employ and who you are employing? Either on a theoretical level or in a very detailed statistical way. The problem now is that we're not just dealing with legal risk. As we mentioned, the view of the federal government right now is a practical matter, and what they perceive to be discrimination, whether or not there's a current case that holds a particular, tenant or specific statute on it, that practical and political risk has become just increasingly important over this year. As a practical matter, engaging in any type of balancing effort right now is very high risk. I think without exception, every client I've advised this year has walked away from any effort to engage in workforce balancing because it is misconstrued, right? Things are very simplified right now, and nuance has sort of been lost in the DEI space, right? So from the administration's perspective, if you say, I want to improve the representation of one group, that's perceived as necessarily wanting to give them better or preferential treatment and wanting to, act to the detriment of somebody else. And so any type of workforce balancing, any numerical goal, Lawfully, they can be defended if they're done right. This is a practical matter. There's just a great deal of risk associated with those.
So, what if I'm an executive in an industry that historically has low female representation in our upper ranks, and I'm looking at two equally qualified candidates for a VP role. One male, one female. They're both stellar candidates. Can I use gender as a tiebreaker just because, historically we just haven't had many female VPs in the company?
No. So, as Christy mentioned, any selection decisions that are based on a protected status, no matter how well intentioned, if we're trying to, remedy historical discrepancies, that's still illegal because we're making a decision based on protected status. Um, so in this situation, you would want to look at other metrics that were specifically related to the job qualifications and the responsibilities that that person would be doing on a day-to-day basis to make the decision. So I believe you said this was a VP role. The decision maker would really need to go back through each candidate's qualifications with a fine-tooth comb and assess things like their relative ability to cultivate internal and external relationships, their existing connections within the target market, whether they have any interest in innovation, things like that that are really going to drive excellence while they're in role. And this also relates to Christy's point about practical application of aspirational goals, right? So if the company in this situation, if the company did have an aspirational goal that were tied to bonuses, for example, and you did have equal candidates like this, it might invite the decision maker to make that decision based on a protected status where they wouldn't otherwise.
So I know there's maybe we can move forward to slide 8 and slide 9. Christy and Elizabeth, maybe there's something in those slides that you might be able to tie into what we were just talking about.
And I was going to add to building off what Elizabeth said, this possibility of using race or gender as a plus factor, as a tiebreaker. We get these questions, right, Elizabeth, from clients all the time. And my answer has become, if you can ever show me two truly identical candidates, then we'll talk, right? Because there is always something you can use from a merit perspective, from substantive qualifications to distinguish between two people, even if it's 6 months more experience or, one extra certification. I guarantee you that if you try, you can find something other than race or gender to break that tie. And that's really what employers need to do. Yeah.
I don't know if we're having trouble with the slides. My screen, they're not moving on my screen. I don't know if you guys are seeing slides. There we go. 8, 9. Okay, yeah, there we all right. Continuing on the recruitment theme, Christy, what about hosting or attending diversity job fairs? A lot of our clients do that or used to do that, or attend recruiting events at historically Black colleges and universities. Is that still lawful?
I would certainly say yes. And the reason I say I would is because there was another memo. This is referencing some March guidance. There's another memo, I think, on the next slide that just came out on July 29th that does cast some question over this area. But here's what I would say, Steve, about the recruiting activities you mentioned, like a job fair or using diversity job boards or going to HBCUs, right, to speak to student groups. That's what we call top of the funnel conduct, right? Your funnel is your selection process. Once somebody applies for a job, they are in the funnel. And as soon as they have applied for a job and the employer might look at them to see how they would fit a role, diversity can have nothing whatsoever to do with that decision-making process, right? It's essentially insulated from any diversity characteristics. But the top of the funnel, before people apply to a specific job, that's where you have your recruiting, your sourcing, your outreach, your activities that are going out and saying, hey, we want you guys to know about us as an employer. We want you to know we have opportunities, and we really want diverse candidates to apply. right? Because the more diverse candidates apply in the broad sense of the word that Elizabeth mentioned, the more are available for consideration and the more might be hired on the merits as the best candidates, right? If you don't apply for a job, you can't get hired for it. And so there's no specific tangible employment action there. I would argue there's no potential violation of the law because all you're doing is sort of casting a wide net and making sure you're considering talent in all sources. The only caveat, do you want to go ahead, Steve? Sorry.
No, go ahead, please.
And say the only caveat, that actually is one of the areas where I've been very comfortable this year telling clients I can still give you a green light, diversity recruiting is fine, low risk, go for it. And then we get this July 29th memo from the Department of Justice. And in that, there is a section where they talk about diversity outreach. And they say that the administration could view it as problematic if an organization or a geographic area or a group is being chosen for activity solely because of the race or gender of the participants. Well, that sounds a lot like what I just described, right? If you're going to an HBCU, it's because it's a historically Black college or university, and you want to make sure that those folks are aware of your job opportunities, right? I still think there's nothing problematic about that under the law. But what we've started telling clients is be clear in your articulations that the reason you're going to an HBCU is not because you want to hire a person of any given race or gender. It's because you want to be capturing all available talent and getting the best people to apply for your jobs. So context and wording has become really important.
Going back to workforce balancing for a second, we've got an audience question. Does workforce balancing still pose the same risks if it's done at the application step versus sort of the talent selection step? So in other words, effectively trying to expand the talent pool as opposed to influencing the actual hiring decisions.
So I can jump in, and Elizabeth, you can weigh in with your thoughts. I think it depends on what you mean by the application step. If you mean once people have applied, you're looking at the ratio of different genders and races in your candidate pool. If you are considering them individually as candidates in that balancing process, there is still a risk under laws like Title VII. If what you're doing is saying, again, we just want to make sure we're considering a whole bunch of people from all these different places, we're going to monitor activity to make sure they're getting in the pipeline before we've looked to see how many years of experience they have or what their degree is, that is still okay. And that would fall on the side of the permissible outreach and recruiting. But once you start vetting the candidates and comparing them to one another, that's where balancing has the risk.
Yeah, it seems to me that once you start making any kind of selection decision, whether that's narrowing a group of resumes or rejecting resumes, then that poses risk, even though you're not actually making the final hiring decision. One more question about the January memo that came out. I think part of the memo touched on proxy questions or proxy factors, Elizabeth. Obviously, that relates to sort of, candidate interviewing. So we are further ahead in the recruitment process. What does that mean? And are those questions now unlawful to ask during an interview?
Right. So it's a similar inquiry as to what Christy mentioned with respect to the recruiting. The memo explicitly warns that you can't use those facially neutral questions as proxies for protected traits with the intent to drive demographic outcomes. So some examples that they called out were like diversity statements that are used to advantage candidates with protected characteristics, those recruiting strategies that Christy mentioned, and then also like job criteria that are kind of vague, like cultural competence, lived experience, cross-cultural skills, things like that. If those are used and applied in a way that advantages candidates based on their racial or ethnic background, then that's not okay. But if you are genuinely considering people of all backgrounds, irrespective of what their protected characteristic is, and considering those in making the decisions, then that's okay. This again harkens back to my my statement on inclusion and belonging principles. If a company is really trying to ensure equal access for all people, and then they're not really running afoul of this prohibition on proxy practices. One thing I do want to just caution people on is to really in their discussion of candidates, not to talk about wanting to hire a person of a specific group for a role. I know for those of us that do employment discrimination litigation, it's very rare for a manager to actually have a piece of writing that says, I fired this person because they're Black or because they're LGBTQ or a woman. But in the context of DEI programs and practices, I have seen correspondence and documents that explicitly say that we want to hire a woman or a person of a specific race for this role. So it's really important that we, tell all internal stakeholders that protected status is never an appropriate consideration in developing any DEI initiative, and we certainly don't want them to be discussing any selection decisions where they're considering protected status and communications that could be discoverable in litigation if that happens.
That makes sense. Let's touch on and discuss maybe some relative risks associated with some other common DEI practices. Christy, a lot of clients have scholarship programs. Are scholarships still okay if they're premised on race or gender?
So some tough questions here. Legally, it's a little bit of a gray area because scholarships are not going to implicate laws like Title VII, right? Because they're not employment decisions. What's at issue there instead are laws like Section 1981, which is a federal law that prohibits race discrimination in any type of contract, or a number of state counterpart laws that prohibit contract discrimination based on gender and other things. But there's a question, is a scholarship really a contract? Where two people are bartering, or is it more akin to a gift or a donation because you're giving somebody this money for school? So legally, I think that still needs to be resolved out there. But again, we need to think about this separate piece of practical and political risk. And there, I think the answer is there is definite risk associated right now with having any tangible benefit or opportunity, especially a financial one, that is exclusionary based on race or gender. And a great example of this was a lawsuit against McDonald's it was either earlier this year or last year. They had a HACER scholarship, which was awarded to individuals. The initial criteria was they had to have at least one parent of Hispanic origin, right? That was the criteria, and they were sued by one of the conservative advocacy groups alleging race discrimination. They ended up settling that case, which is why we, again, don't have a clear legal answer. But the way they settled it was they changed the criteria from focusing on the ethnicity of the individual to whether they support the Hispanic community, whether their actions supported the Hispanic community. So they were still able to focus on a particular demographic in terms of where the interest was, without excluding anyone based on their particular race or ethnicity, because anybody could engage in those efforts. So that's the direction that we're seeing employers go in to mitigate that risk.
Yeah, that sounds like a creative workaround. Elizabeth, what about career development and mentorship programs at work? If they're geared to or focused on minority or underrepresented groups, is that still lawful?
So those programs are also high risk because eligibility for those programs is based on protected status. So if there's a mentorship program that's exclusively for women or for Black or for Black people, individuals that don't fall within those demographics wouldn't be eligible for those programs and any benefits that are associated with those programs. And they could, very easily say that they're being treated differently because they're based on a protected trait. So those programs need to be open to all. One thing employers should keep in mind is that separate but equal mentorship programs aren't okay because you're still predicating eligibility based on protected status.
Let's go to the next slide, slide 11. Christy, I wonder, does the same analysis apply to employee resource or affinity groups, right? Are those now high risk? Um, Elizabeth touched on sort of the separate but equal type of dichotomy. We're also seeing increasingly, religious-based ERGs. That's kind of a hot topic. Maybe you could address that.
Sure. Yeah, ERGs is one of the areas where we get probably the most questions since the executive orders came out in January, because they're such important resources for employees, right? People really care about their employee resource groups or their affinity groups. And historically, they have been structured along racial or gender or sexual orientation or disability lines, things like that, identity-based groups. The answer is, and here's where we have some good news for those who still want to engage in DEI-related efforts, employee resource groups are absolutely fine as long as they are open to anyone who is interested in the mission and the purpose of the group, and truly welcoming of those people. So not just open on paper, but, exclusionary in practice. And so as an example, if you have a women's networking group within an organization, and that's the women's-based ERG, as long as anyone is welcome to attend, they can still focus their topics and their subjects on issues affecting women. But plenty of men are interested in those topics. Men have sisters and mothers and spouses and, other reasons to be interested in those topics. And so as long as it's not exclusionary, those are still okay. Okay.
No, I've got another follow-up question, but if you're not done, Christy, by all means.
I was just going to share what's become one of my favorite anecdotes in this space, right? So we had a client this spring who had a women's ERG, and they wanted to host a discussion session on menopause. And they called me and they said, so we really would like to limit this discussion to only women because we want them to feel comfortable talking about this. It's a women's issue. Can we limit it to women? And I said, unfortunately, you probably shouldn't right now, right? There's some risk if you say it's men aren't welcome to attend. And so they were a little hesitant, but short version is they opened it up. They had a number of men attend because they wanted to know what was happening to their wives. Absolutely wonderful, really all-encompassing discussion that nobody would have anticipated happening, right? And I use that as an example to say it doesn't undermine the purpose of an ERG or an affinity group to open it to people outside that, sort of target population. And you may actually get a lot of unintended benefits out of it.
So, we're in the middle of Hispanic Heritage Month, and as some of you might know in the audience, I'm originally from Argentina. I also happen to be the unofficial DJ of our annual Hispanic Heritage Month celebration. Are Heritage Month programs and celebrations still okay? Or, Elizabeth, do I have to give up my DJ side hustle?
No, Steve, you're in luck. We can still catch you on the ones and twos. Seyfarth's a private employer, so I know that we have seen cancellation of Heritage Month programs and things like MLK celebrations within the federal government pursuant to Executive Order 14151, which we did not cover today, but that EO directed federal agencies to terminate their internal DEI initiatives. That executive order doesn't apply to the private sector. So you can, go forth with your Heritage Month programs and celebrations. When planning those cultural programs, you should ensure that the programs are open and welcoming to all, of course, and also review them for content to ensure that there's not anything that's could be potentially offensive or racially hostile to any groups and attempting to be educational.
Let's switch gears. I want to spend a few minutes talking about EEO and anti-harassment training. I've seen, Christy, in some contexts, the government is saying, well, you can't train on gender identity, critical race theory, these other so-called, quote, woke ideologies. And some of this, we're seeing playing out in the courts. We're seeing employees file lawsuits claiming that mandatory DEI training creates a hostile work environment. And, just last week, I saw the Second Circuit, up in New York, reinstated a harassment lawsuit by a worker who claimed that, implicit bias training at his workplace stoked racial animus against white employees. And if anybody's interested, that case is Chislett versus New York City Department of Education. Um, Against this background, Christy, I wonder, should employers modify their EEO, anti-harassment, annual onboarding training, things like that?
The vast majority of EEO and anti-harassment training is still absolutely fine and no changes need to be made. I mean, remember that equal employment opportunity and non-discrimination is still the law, right? Under a host of both state and federal laws. So training that's geared towards that is fine, and it's actually still required under Title VII as well. Where things get tricky is like the Chislett case, where you get into things like what President Trump calls the shaming and blaming approach to discussions of race in particular, right? And in the Chislett case, there was training that called out white culture as supremacist, made a number of statements generalizing about whites. That's not okay any more than it would be to do it about any other racial group, right? So if there is training content that seeks to sort of polarize the groups instead of bringing them together and focusing on inclusion, as Elizabeth mentioned, that does merit another look. Most of the training that we see is not like that. Good DEI training, in my view, is not going to take that approach because it's not unifying the way you want it to be. Another thing to make sure is that DEI training generally should be voluntary if it's on the DEI side. So things like implicit bias training, microaggressions, things like that. That goes a little bit past just the equal employment opportunity and non-discrimination. You might consider making those optional, and so that folks have a choice whether to attend, because in the lawsuits that have challenged training, they've done it on the basis that they were sort of captive audience. They were required to attend. They didn't have any choice. And so they've alleged that it created a hostile work environment. I would add, by the way, that those cases have not fared very well in the courts so far. I think Chislett is the first one where the plaintiff has actually been able to proceed with an allegation. And there were other facts in that case, like statements made outside of training, that contributed to that. But in general, it's fairly hard to make a hostile work environment claim based just on the training alone.
Yeah, I think the facts in Chislett were egregious, and maybe that's an outlier. Christy, there are some states, Texas is not among them, but there are some states that do require, specific EEO, anti-harassment, other workplace trainings. Are you seeing any sort of tension or conflict between what the federal government is saying about trainings and what some states might require?
Thankfully, no. As you said, there are specific state requirements, and there was concern when these orders came out that there could be a conflict, but we're finding that really not to be the case, again, because so much of what those trainings are geared towards is still both permissible and important under the law. There are some nuances to how we're advising clients to go forward with things like implicit bias training, for instance. I always suggest that they look at the examples that are given in implicit bias training. There are often hypotheticals or scenarios. Make sure it's clear that anyone can be both the holder and the target of bias. It doesn't just flow one direction from one gender to another or one race to another, right? Anyone can experience bias in all of its forms. And if you include that sort of holistic approach, then you get away from that shaming and blaming concept that the administration finds problematic. And so that helps to reconcile the different requirements as well.
Another interesting sort of development that I'm paying attention to is, this sort of tension or potential conflict between the government support for religious rights, religious expression at the workplace, and maybe other workplace rights. And what I'm talking about a little bit is, how should employers navigate DEI training with LGBTQ or gender identity components that may conflict with the religious beliefs of some of their employees? Should they just get a pass? Should they be forced to attend? Are there other considerations at play?
Yeah, that's a more complicated issue, I would say, and one sort of not fix exactly, but one easy approach to take is making it optional, right? Because then you take away the argument altogether that I didn't have a choice, I had to sit through this. But even if you're going to address issues like LGBTQ in your annual anti-harassment training, for instance, because sexual orientation and gender identity are still protected under Title VII right now, right? So it's appropriate to address those in certain contexts. What I think is really important is to acknowledge in the training, whoever is moderating, to acknowledge that it's a difficult topic and it's one on which people can have different personal opinions. But what the training is about workplace expectations, right? And obligations under the law, and ensuring an accepting and inclusive environment for everyone. And so it's still appropriate to explain what the expectations are for people in terms of the respect and civility and the way they treat their coworkers in the workplace. But making it voluntary is still a pretty important component too.
Yeah, I see that sort of as an increasing litigation risk, compliance risk, and we are seeing cases where, again, either employer practices or coworkers, there's this tension between religious expression, religious views, religious accommodations, and workplace policies or workplace standards. Let's switch gears a little bit. I want to focus. I know we have a number of clients and other folks on the call here who are federal contractors, and we know that the federal government has been active rolling back DEI affirmative action requirements for federal contractors, but contractors are also being asked to affirmatively pledge that they are not implementing, quote, illegal DEI practices. Elizabeth, I wonder if we can focus a few minutes. How does this affect federal contractors specifically, and are there special or additional changes or precautions that they should be thinking about?
Sure. So just to provide a little bit more context on this, Executive Order 14173, as I'm sure the federal contractors on the call know, eliminated the federal contractors' affirmative action obligations with respect to race, ethnicity, and gender. It did not remove those requirements with respect to disability or veteran status. So whereas previously federal contractors would be making decisions to actively get women and ethnic diversity in their workforces, now they cannot do that, or they will be implementing illegal DEI practices, right? So to combat against that risk, contractors should have revised their policies and any notices and postings to remove references to DEI or affirmative action that's based on race, gender, or ethnicity. And if we haven't done so already, we should be conducting privileged internal audits of all employment, recruiting, training, compensation programs to identify any elements, any holdovers that are still considering race or gender in their employment practices. What things you should be looking for: race or sex-based placement goals, things that Christy spoke about before, DEI related training or mentorships programs that are limited to specific demographic groups, things that would be high risk in any other context, specifically to contractors. Also consider, documenting in one place all of the actions that you've taken to discontinue those efforts and comply affirmatively with the new executive order. And just, as a final note for all employers, not just federal contractors, we always have obligations to ensure non-discrimination in selection decisions and compliance with Title VII. So it's still just best practices to continue to monitor and analyze employment decisions by race and gender. So even though it's no longer done under the auspices of affirmative action.
So, we hear about, the potential for, losing federal grants, losing federal contracts if, contractors are not in compliance with these new standards or these new rules. I've also heard a little bit about potential False Claims Act liability. Elizabeth, what's that about?
So with respect to the funding aspect, if you're a grant recipient, you have to be particularly careful because the government can just yank the funding. And then you have to go to court to say that the yanking was improper, which obviously is not ideal because your budget's already crunched because you don't have the funding and now you're trying to spend legal funds to get it back. It's just not a good situation to be in. So if you're a grant recipient, you really want to keep an eye out for that. With respect to FCA liability, all federal contractors now, they have to include terms that specifically say that they're in compliance with all applicable federal anti-discrimination laws, and that compliance is material to a payment decision, and that the organization also has no illegal DEI in its practices. So this new certification requirement is what we're calling it, intentionally creates a new way to bring false claims acts. So by explicitly making anti-discrimination compliance material to the payment decisions, it says that certifications about DEI programs that are subsequently proved to be false will provide a basis for a liability under the FCA. And this is particularly concerning because there are treble damages associated with FCA lawsuits, as well as civil penalties, and you have exposure on both sides. You have government exposure, and you also have whistleblower exposure through private litigants.
So it sounds like, for all of our federal contractor clients, it sounds like their OFCCP experts really need to partner with both of you before they sign off on those certifications. That seems very important. We've talked about, risks or relative risks associated with various DEI practices. Maybe we can spend a little bit of time talking about, practices that are, sort of, compliant or green light, or we know that they're going to be lawful moving forward. Christy, maybe you can cover at a high level some green light recruiting practices or best practices for DEI in recruiting.
Yep, absolutely. And I know that some of the type is a little small on this slide, but hopefully it's helpful to just have sort of higher and lower risk buckets for folks to look at. So as we mentioned, trying to expand the diversity of your candidate pool is absolutely fine as a legal matter. And even from a practical risk perspective, I'll be curious to see where the DOJ and the administration tries to go with its reference in the recent memo, because I just don't see any basis for a legal claim there. Encouraging people to apply for a position, encouraging your, wanting to have a diverse group to look at before a decision is made. There's no way somebody can claim they were disadvantaged or excluded based on race or gender, or that they didn't get a job because of race or gender, because it simply is not factoring into the employment decision itself. So I think it's really important to continue engaging in wide-ranging outreach and recruiting. If you are a government contractor, you're still required to do it for disabled and veteran populations as well. So don't forget that. But anything at that top of the funnel point that we were talking about is still okay and greenlit.
Elizabeth, what about you, from your perspective, maybe green light practices to increase belonging and inclusiveness at work?
Sure. So ERGs are, as Chrissy mentioned, a super hot topic, but they're also super popular with employees because they do provide that content that is particularly relevant to people that are of that demographic or interested in supporting that demographic. When implementing those, just make sure that they're open to all. Similar considerations with inclusive mentorship and fellowship opportunities. Want to make sure that all employees are given those types of opportunities. Something that's thought about a little bit less are equal pay for people that are in comparable roles. Just want to continue to conduct those internal pay analysis, even though those are but they are based on protected characteristics to create that feeling of value and inclusion for all employees. Another thing that I've seen clients do is focus on employee experience through surveys. And then that way they can gather demographic information and see how different programs are affecting different groups of people. And they can consider all of that information holistically and then come up with programs and approaches that consider all of that information and are beneficial for everyone. And then also just inclusivity training that focuses on objective goals rather than blaming any particular group for one thing.
So I've got one last question before we do closing remarks. I know that you and Christy have been very busy helping clients update and revise their DEI plans. Some clients have written plans that are a couple of pages long. Some clients have plans that are much more elaborate and go on to, 15, 20 plus pages. What are maybe top 2 or 3 pieces of advice that you can give folks on the webinar today about updating or maybe revising, written DEI plans?
So I can offer a few thoughts, and one of which is that unfortunately the acronym DEI has become very charged. I don't think anybody would dispute that, even though diversity, equity, and inclusion are all still really important terms. We are increasingly starting to use other language, as Elizabeth mentioned, things like inclusiveness, belonging, culture, engagement. Just because they're not triggering the way some of these other words are in terms of attention or, criticism standpoint. So that's first thing, is to look at the word choice. And then just to make sure, again, that nothing is exclusionary, that any opportunity is open to all, even if it's focused on a particular subset or group. Focusing on the idea of bringing everyone together and aiming for people to be their whole selves at work, focusing on that aspect of it and the belonging. Those are the types of things that employers want to be looking at.
Elizabeth? Yeah.
I agree with all that, Christy. I think that something else to consider when thinking about the programs is evaluate the program and think about, is it working, right? Like, is this something that's creating the inclusivity or diversity or whatever your goal is for that particular program? And if it's not working and it's creating a practical risk, why do we have it, right? Or in what way can it be revamped to further the goal in a way that doesn't expose us to risk? So I would just be thinking about it in that framework. Because you certainly don't want to litigate over something that's not even doing what you want it to do, right? So
Good point. Let me give everybody the CLE code, and then we'll hand it off and do closing remarks. The CLE code is SS0998. Again, SS0998. Everybody will get a copy of the presentation, including the slides that we didn't get to cover on religious accommodation. Here you can, there's QR codes for our contact information, our bios. On the last slide, I think we have our email addresses. Here's the QR code for CLE credit. Again, SS0998. Christy, Elizabeth, closing remarks.
Elizabeth, do you want to go?
Sure. I just want to thank everybody for coming. I know this is a really it's a complicated space. There's been a lot of movement here. And I know that it's important to a lot of companies to continue this work. And we're here to help you guys navigate through this in whichever way you choose to go.
I would add, I guess, sort of two different thoughts. One is, Steve, this was my oversight. You asked questions about ERGs and religious ERGs, and I realized I didn't address the religious piece in my answer. And I have gotten more questions about religious ERGs this year than my entire rest of my career put together. So just a very short answer on that is that religious ERGs, the way to approach them is going to depend a lot on the culture of your organization. The one bright line rule is that you cannot allow ERGs for certain religions and not others. So you can either categorically say, we don't want to open the door to religious ERGs, just like you don't open the door to political ERGs, and have that be a ban that you enforce consistently. Or you can allow religious ERGs, in which case you have to be open to considering them from any faith or religion. Or you could create a single interfaith ERG where people can come together and discuss religion and their particular faiths generally. So a lot of different approaches there, but they certainly can be permissible, and I think they're becoming more common. And then the last thing I would say is, and this goes back to your question about looking at programs, remember that a lot of people still really care passionately about DEI work. And notwithstanding the increasing legal and practical risks, there's also a countervailing risk to walking back too far. And I don't want to forget that piece of it, because stakeholders, whether it's employees or boards or whoever it is, still really care. And so you have to be threading that needle exactly right, which is admittedly not an easy thing to do.
Fantastic. Well, right on the nose, 1 p.m. exactly. Elizabeth, Christy, it's wonderful talking to you. It's been a great presentation. We hope everybody got something out of the discussion today. Christy and Elizabeth are experts in this area. They've been helping clients through this for years. I encourage anybody who has questions, who needs help looking at their EEO or anti-harassment training, looking at their DEI plans, whether it's written or structural, any other questions, please reach out to them. We're here to help. And any questions that we did not address, we will address in writing to the registrant. So I hope you enjoy the rest of the afternoon. Thanks everybody for joining us.
Bye.